Hello, everybody. I'm Nate Eaton with EastIdahoNews.com. Just days away from jury selection in Lori Vallow Daybell's case in Arizona regarding the attempted murder of Brandon Boudreaux. And the judge has issued a big response to Lori's request in regards to her first Arizona trial. Remember, a few weeks ago, she was on trial in Maricopa County for a conspiracy to commit the murder of Charles Vallow. Trial lasted about 2 weeks. The prosecution presented several witnesses. Lori Vallow did not present one. She did not take the stand. She did give a closing argument and an opening statement, but ultimately the jury found her guilty after just an hour or two of deliberating. It went quite fast. Well, immediately after the trial, Lori Daybell filed a motion to have a retrial for several reasons. She listed several reasons in her motion why she felt she deserves another trial. Because one, juror misconduct, two, preclusion of Tylee Ryan and Alex Cox's statements, the fact that those statements were not allowed in the trial and that there was impermissible testimony by a detective. The third reason she wanted another trial is because she claimed there was a discovery violation. The fourth reason was she accused Trina Kay of misconduct. And the fifth reason was she said that the court was not impartial, that the judge was unfair to her and showed a bias, and because of all of these reasons, she asked for another trial. Well, Judge Justin Beresky has responded and denied that motion. In fact, he did it in a 5-page document that just came out a few days ago, just this week, and I'm going to go through briefly what he said in response to her. First was the juror misconduct claim. Do you remember this? There was a juror who walked out of the courtroom. The media, we instantly, ran over to him and started interviewing him. And at one point, he said to a reporter that he was thinking about Lori and the fact that she would be serving 3 life sentences the night before as he drove home. Well, that would have been when the jury was still in deliberations and the jurors should not have known about her prior cases. So Lori said, because of that, we need a retrial. And the juror was wrong. Well, in the prosecution's response to Lori's filing, the prosecution quoted other instances in that same media circle where the juror himself said he didn't know about it. And he went on to clarify it later on. And this is what the judge responded concerning that allegation. He said, the defendant alleges there was juror misconduct based on the statement juror 15 made to reporters following the verdict, wherein he said, quote, I feel sorry for her driving home yesterday. I was like, God, she's spending the next 3 lives in prison in a cell, end quote. On its face, this statement would seem to indicate the juror violated the admonition and researched the defendant, acquiring knowledge about her sentence imposed in another matter prior to the lifting of the admonition. However, the state's response included multiple additional media clips of statements juror 15 made, both immediately prior to, after the statement referenced here and above, in every one in which he specifically denied any knowledge of Daybell's other case or sentence prior to the court releasing the jurors from their admonition. At best, juror 15 gave a single statement, which seems to be in conflict with all his other statements, which he specifically denied any misconduct. Here, on the limited record of the pleadings before the court, there being no affidavits or sworn testimony evidencing any misconduct as contemplated, the court does not find a clear indication of juror misconduct, let alone any evidence of prejudice to the defendant. Juror misconduct requires a new trial only if the defendant shows actual prejudice, or it can fairly be presumed from the facts. Lori didn't include any affidavits to her motion. She didn't include any statements from other jurors, whatever. She didn't include a statement from this juror that her investigator could have reached out to, I assume, and talked to them. But based on that issue, denied. Second issue was the fact that the judge did not allow in statements that Tylee Ryan and Alex Cox made during their interviews right after the shooting of Charles Vallow, simply because they're hearsay, because they're both dead and they can't testify to the fact that they said those things. And the other issue, Lori said, is that one of the detectives who testified, his testimony should not have been admitted because he was there as an expert and some other reasons. Well, the judge responded to that. The court issued a pretrial ruling in March regarding the inadmissibility of statements made by Tylee and Ryan. The court's ruling stated that out-of-court statements made by them appear to be hearsay, and the defendant failed to establish that any specific statement was either not hearsay or fell within an exception. The court went on to give the defendant the opportunity to offer specific statements at trial by stating the defendant could re-urge the issue outside the presence of a jury. So basically, if there was a moment where Lori said, at this time, I need this specific statement Tylee or Alex made, the judge would have excused the jury. Lori would have argued why those statements were needed. The prosecution would have responded, and the judge would have ruled. Had the judge said, yes, those statements were needed, boom, the jury would have been allowed back in. Lori would have presented this statement, and it could have gone on. That did not happen once. The court goes on to say, the judge, the court went on to give the defendant the opportunity, not only did the defendant never take the court up on the offering during trial, the defendant's motion for a new trial and reply only argue in generalities, failing to set forth any specific statement that should have been admitted into evidence under either a non-hearsay exemption or an exemption to the hearsay rule. So that is denied. Next issue that she raised was a discovery violation. She claimed that evidence from Charles's hard drive on the phone, his phone evidence, was turned over to her team late, and that her expert did not have time to evaluate it. The judge says, although the defendant's motion alleges the contents of the hard drive are, quote, exculpatory, she never articulates any single item whatsoever that would constitute exculpatory evidence. Again, merely stating something is, quote, exculpatory does not make it so. The defendant's request for additional discovery related to Charles Vallow's phone was accommodated. The state had previously disclosed all evidence it had in possession at that time. The defendant requested access to the actual phone to run a new examination with software that had been updated since the phone was examined several years ago. The defense has offered no evidence that any additional information was obtained from the phone, let alone it being exculpatory. The court finds no discovery violation. Next issue, prosecutorial misconduct. The court finds nothing in the defendant's allegations come close to establishing prosecutorial misconduct. The state is allowed to argue reasonable inferences from the evidence presented. The defense does not have to agree with those inferences and is permitted to argue the evidence should it be interpreted differently. The defense argues in her reply for the first time that both the state and the court violated the defendant's right under the Religious Freedom Restoration Act. Although new arguments are not to be considered when raised in a reply, the court will nonetheless address this. This comes down to the fact that the judge made a statement when Lori was questioning witnesses. This was raised in her motion for a new retrial. When she was talking about some of the faith beliefs of a witness, and she was questioning this witness, the prosecution objected. The judge then stepped in and said, well, if you're talking about, I'm paraphrasing here in a major way, if you're talking about religious figures and comparing yourself to a religious figure, I will let the questioning happen. Well, for the first time, Lori never brought up in the trial the fact that the Religious Freedom Restoration Act, never brought that up. She is here, and the judge says, you know what, I'm going to address it. He says, the act protects religious freedom and prohibits the government from substantially burdening a person's exercise of religion. There is no conduct by either the state or court that somehow infringes on the defendant's freedom to practice her religion. Nor is there anything about the trial that impacts the defendant's freedom to believe whatever she chooses to believe in. Moreover, the Religious Freedom Restoration Act does not protect someone from committing criminal acts in the name of religion, nor does the act prevent any person from disagreeing with another person's belief system. Here, different witnesses may have different interpretations regarding who Nephi was, or the significance of that story. The defendant had an opportunity to cross-examine these witnesses regarding the same. None of this infringes on the defendant's religious freedom. For these reasons, the court finds no prosecutorial misconduct. Lori had an issue because Nephi was brought up, and Nephi is a figure in the Book of Mormon who was commanded by the Lord to kill someone who the Lord said was wicked. And Lori went on to argue that, which of course Lori believed that Charles was wicked. And so the inference was that she considered herself a prophet, a goddess, and that God was telling her to kill this evil man, Charles, her husband. Well, she argued that Nephi is referenced, that there's multiple Nephis in the Book of Mormon, and that there's multiple stories in the Book of Mormon about the different Nephis, and how could they just cherry pick this one fact about Nephi and apply it to the trial. Final reason that Lori asked for a continuance, or for a new trial, not a continuance. We already had the trial. She said the judge was unfair. The court was impartial. The judge responds, the defendant alleges the court was not impartial because the court struck two of the defendant's witnesses from the defendant's witness list. Oh, okay, yeah, forgot about that. Lori asked for me to be a witness, and she asked for Brandon Boudreau to be a witness. And the judge said both of us were struck from the witness list. We argued, and we hired an attorney and said, I have no knowledge of the case other than what I've reported, other than what people have told me, and my sources are protected. And Lori wanted to put me on the stand, she told the judge, because I could impeach the witnesses, meaning if they said something wrong, I could get up and say, actually, I interviewed this witness and they said this. She said that I had interviewed all of her witnesses. Not true. For this case, I had interviewed two, Kay Woodcock and Adam Cox. I didn't interview any of the detectives or any of the firefighters, any of the experts, so I don't have interviews to talk about that with. She also wanted Brandon Boudreau on the stand, and the state argued that he did not have pertinent information about this particular case. And Lori said, well, he does. And the judge said, well, he doesn't. But the judge left the door open that if Lori could come up during her defense portion, a reasonable, valid legal reason why me or Brandon should take the stand, the judge would reconsider it and possibly allow it. Well, she never brought us up again. And so but until she filed this motion for a new trial. And in that motion, she said, the judge struck me and Brandon off the list before the trial even started, and that was unfair to Lori. So the judge responds, contrary to the defendant's assertion that no rule of law or evidence requires her to establish a witness has relevant information, Arizona rules of evidence require just that. Prior to trial, the defendant was given an opportunity to make a general offer of proof as to what relevant information the witnesses would provide, which the defendant was unable to provide. When the court precluded the witnesses, the defendant was also advised by the court that during the course of the trial, if she believed these witnesses had relevant information, the court would revisit the issue. Thereafter, the defendant did not again offer any witness, even though she was specifically told she could. In addition, the defendant offers no further information on what testimony the witnesses would have given if they were permitted to be called as witnesses. The defendant also argues the court demonstrated a bias based on the court's comment made while overruling the state's objection during the defendant's questioning of Serena Sharp. The state was objecting to the relevance of the question, and the court thought the question had some minimal relevance based on the context of the defendant's line of questioning. This is what I talked about a minute ago. When Lori was questioning Serena Sharp about religious beliefs, the state objected. The judge allowed Lori to continue her questioning. The court notes the defendant's argument as to why the question was relevant was not in line with why the court surmised it was relevant. While the court's comment was not necessary, it does not evidence bias, nor does it mean the court was demonstrating any partiality. Nonetheless, the court acknowledges the court's comment was unnecessary, and the court should have simply overruled the state's objection without comment. Moreover, the court has been presented no evidence whatsoever that this comment influenced jurors. Having carefully considered the defendant's arguments, all of the briefing, and on the record, the court finds the defendant received a fair and impartial jury trial, and the defendant has failed to establish any ground for a new trial. It is denying the defendant's motion for a new trial. So Lori is not getting a new trial. Will she appeal? Absolutely. Defendants always appeal. That's not abnormal. They probably are preparing the appeal right now. How far up the appeal goes, we'll see. It's not a death penalty case. In death penalty cases, appeals last forever, it seems. That's what's happening with Chad Daybell's case. And it goes to different courts, and it goes to different judges. In Idaho, it ultimately ends up at the Supreme Court of Idaho in the death penalty case. And that's honestly where Lori's case in Idaho will probably end up too, at the Supreme Court, because they will rule on her appeals Those, by the way, an update on that is that her appellate attorney has filed multiple motions asking for more time, because what he has to do is get a transcript of the trial, of every word that was ever spoken at the trial, and that can take time. He has to review it, and he's looking for legalities as to why Lori Vallow, why the court erred in granting certain motions or judgments or whatever. And then he presents his argument, and then the Attorney General of Idaho represents the prosecutors. And the Attorney General will say, here is why there shouldn't be an appeal, why the appeal should not be granted, and then that goes before the Supreme Court. That will probably be years away. It is, possible that once Lori in Arizona is if she's found guilty in this case, this Brandon Boudreaux case, that she doesn't file an appeal, but I don't see it happening. I think they would just do it, and based on what she's doing now with these filings, I could see it happening. So what happens next? Well, off to Arizona I am next week, early next week. You can follow along. I'll be posting updates on my Facebook page, Nate Eaton Reporter, on my Instagram, n.eaton. Also here on YouTube. Tuesday night, we're going to do Ask Nate Anything. Within reason. I don't think you want. Within reason. What's going to happen is we're going to go live on our YouTube channel sometime, depending on where I'm at on the road, and as long as I have a good signal. We're going to go around 6 to 8 o'clock Mountain Time on the East Idaho News YouTube channel. So tune in sometime around there, and you can ask a question. Put it in the comments. Peggy's going to be joining me. You'll get to see Peggy in the flesh. I'll be driving, so I'll be focused on the road, but she's going to be asking me questions from you, and I will be answering those questions, and hopefully that can clear up any thoughts you have about the trial. So I'm going to head down to Arizona early next week. Thursday is when jury selection. So actually right now, in the next few days, the potential jurors have been getting e-questionnaires that they will fill out. They will then be brought down to the courthouse. They will go through that list on Thursday afternoon. The judge, the prosecutor, the defense, they will strike names that they feel shouldn't be on the jury. This process went fairly quick in the last trial with Charles Vallow. And then on Friday, the potential jurors will actually come in person to the courthouse, and they will go through, and the jury will be picked. The jury will be picked. There will be 12 jurors, 4 alternates again, like last time. And then the trial will begin a week from Monday, June 2nd. Prosecutor will take 4 days that first week and get through what Trina Kay says should get through all of their witnesses except 3. And then Friday, there will be no court. Possibly Thursday, there will be no court if she gets through them all on Monday, Tuesday, Wednesday. Opening arguments, opening statements will also happen Monday, of course. And then the following Monday, the prosecutor could finish her 3 witnesses that Monday, and then it's turned over to Lori. If Lori does what she did before, she won't have a defense. She could have a defense. Right now, we don't know what witnesses she's going to call, and the deadline's passed, but we'll see. She could also take the stand, which I think we want, right? We're all hoping for that. But if not, that's okay. That's her right. She doesn't have to, and she does not have to persuade the jury that she is, that she did anything. She can just, remain quiet. And so we'll see what happens there. And then the trial could continue the entire second week of June, except for Friday. No, actually, it could happen on Friday. Or the jury could reach a verdict that week, and it could all be done. If they don't have a verdict by the end of June 13th, then the court is dark for a week, and then we'll be back on the following Monday. I think it's June 23rd. So we will be there for every step of the way. It is June 23rd. And we will be there along the way. And every night, Courtroom Insider, 8 o'clock. Hope you'll join me here wherever you're watching right now. YouTube mainly is the best way, probably on eastidahonews.com. For those, the time zone breakdown, let me explain, because many of you have emailed me from overseas saying, I don't get it. How do I figure out the time I want to watch live? It's 7 o'clock Pacific time and also Arizona time. Arizona doesn't do daylight saving, so it's in a niche of its own during this time of the year. 8 o'clock Mountain time, 9 o'clock Central, 10 o'clock Eastern. I wish it could be an hour earlier, but it doesn't give me enough time to prepare. What you can do, go to Google, wherever you're at, and type in when it's 8 o'clock Mountain time what time is it where I am, or wherever, in Italy, in Australia, and wherever. And it should tell you, and that's when you know you can join. And also, if you miss us live, you can always find we keep these episodes up forever. Go to the East Idaho News YouTube channel, click on the live tab, and you'll see them all right there. You can watch them all right there. So you will never miss them. And for those of you watching on Meetin' the Eatons, thank you so much. That's our family YouTube channel, and I'm posting content on there too. But most of it is on eastidahonews.com. All right, I think we have it all covered. That is the latest on Lori Vallow's request for a new trial, denied. It won't be happening. There are a few outstanding motions that the judge will likely take up before the jury comes in next week. But other than that, we will see you on the road. I hope you have a wonderful Memorial Day weekend if you're in the United States, and that there's a beautiful field of honor with American flags in honor of all the servicemen and women who have died over the years at the Fielding Park in Idaho Falls. It's just phenomenal. We're going to head out there and visit that, and remember our loved ones and remember those who are lost. And thank you to all who serve and all of the law enforcement and everybody that makes this all happen. I last night my family and I went to a concert in Rexburg, and it's always so nice to see the police officers there that were working security. I chatted with several of them. Sheriff, Bart Quell from Fremont County. It's just good to see those guys. They're good people, and often the police, get a bad rap. And in some cases, and in a lot of cases, it's deserved. I'm not saying that it's not, but in certain cases, but most of the time, these are just good men and women who are doing their jobs and protecting us. And because of their hard work on all of these cases, justice is finally happening and has happened for Tylee, JJ, Charles, Brandon, and families of loved ones, families of these people that will be forever changed. Thanks for watching. I'm Nate Eaton. Have a good day.